trust. That's the way to do it. Well, a lot of clients just name the spouse. We advise them to name the trust, but they forget to. Or they did name the trust as alternate, but then they switched brokerage firms, and for some reason the new brokerage firm almost always gets it wrong, and they don't ask the old brokerage firm what it was. So you really have to be careful. I mean, we do have clients who die, and the life insurance just goes to the wrong place. It goes to the wrong person. It's not available to pay bills. So this is drastically important. And I think if you work with us, you know we do all we can to try to make this right. But when clients do it on their own, or the salesperson promises to do it and doesn't do it, it can be a big problem. Page 17, if you're going to buy life insurance, get all you need. It's more important to get the right amount of life insurance, the payment on death, than it is to get a cash value developed under the policy. That's my opinion. When you go and get a life insurance quote, they can either turn it in as a formal application, and then if you get a health issue during the exam, it goes on the bureau, and every insurance company for the rest of time is going to know about it. Alternatively, you can do an informal application where it only goes to 1 or 2 life insurance companies, and they informally let you know whether they would entertain a formal application. And I think that can be very important. All right, then the next page, so that's page 18, I've got representative term life insurance rates. So if you're watching this right now and you're 45 years old, or your wife is 45 years old, and you would like to see what it costs per million to get her insured, if she's a standard risk, then it would only cost $1,100 a year for you to get $1 million if she dies in the first 10 years. So that might be a good thing. If you have children who haven't finished college and or a child that you think will be done with graduate school in 15 years, then maybe look at adding another 15-year policy so that your spouse doesn't have to go through unreasonable hardship. You know, you used to have a lot of equity in your home. Now your home may be upside down. So think about this term life insurance. They want to sell you the permanent life insurance, but you can buy term life insurance, get it in place. And if you want to convert it to permanent life insurance, you can do that later after you take a closer look. Now, number 5, failure to focus on asset protection planning. That's very important. We just have a lot of clients who have done good estate planning, but they just haven't thought through the asset protection planning. For example, I've had a client come in on Tuesday where the husband owns the car that the child is driving, and the wife is the one who signed the form with the Department of Motor Vehicles to be responsible for the child's negligence. So if that child gets in an accident, they're going to say that the husband negligently entrusted the child with the car, that he wasn't trustworthy to drive the car in the rain or something like that. Then they're going to nail the mother. They're going to get a judgment against both spouses, and then they're going to lose all their joint assets except for the homestead. So it's really important to think through the creditor protection planning. Like using an LLC. If Marcia and I have a piece of property on the Swanee River, if it's under an LLC, then if somebody breaks their neck, I may lose the property and the LLC, but I'm not going to lose the rest of my joint assets. And if that LLC is owned 5% by a trust for our children, and somebody does find a way to sue Marcia and I, they're not going to be able to break into that LLC. Or if I pass away and Marcia owns 95% of that LLC and somebody finds a way to sue her, then they're not going to be able to break into that LLC. So just working on the creditor protection planning can be vitally important. It just has to be reviewed. And we find that there are many, many mistakes made by other advisors who mean well. Now, of course, we mean well as also, by the way. All right, page 21. This is just, you can print this out and carry it in your wallet. These are the creditor-exempt assets on the top left-hand side. Your homestead, only up to half an acre within the city limits. Some clients are buying the homestead next door and making one large complex because this is your safest asset from a creditor protection standpoint, assuming you're not going to go into bankruptcy anytime soon. Your IRA, Roth IRA, absolutely protected. Your pension plan, protected if the plan is handled correctly. Permanent life insurance owned by the person insured is going to be protected. Annuity contracts are protected if they're purchased properly, but there are sales charges involved with these, so you should look carefully or maybe consider a non-loaded or low-cost annuity. Wages of the head of household we're going to talk about because there's a lot of mistakes made there. Wage accounts, which we'll talk about in a little while. Tenancy by the entireties as long as no one's suing both spouses. And then I really like these 529 college savings plans. You can do the prepaid tuition, pay about $44,000 a year now for a 10-year-old to have room and board at a Florida college. But you can also open what's pretty much like a mutual fund. It's sponsored by a state, and it's creditor-proof even though it's in your name and you can use it for yourself. If you pull it out for yourself, then you're going to have to pay income tax on the inside earnings, plus an extra 10% tax. But as long as you spend it on anyone's college, it could be your nephew's college, your future girlfriend's college, anyone's college, you never pay taxes on it. So if you don't have a 529 plan and you have children who are going to go through college, you really need to give that some thought. All right, then assets that are difficult for a creditor to obtain. They're not totally exempt, but they're hard to get into. That's these limited partnerships and limited liability companies, offshore trusts, Nevada asset protection trusts, things that we prefer not to use if we can properly use the other things. We try to keep it as simple as possible, but we also try to keep it logical. Assets exposed to creditors, your brokerage account, your individual assets, your joint assets where you both own money, half of your joint assets in a non-TBE account. You're only allowed to keep physical items worth $4,000. So in some families that would just be half of the shoes and everything else would have to go to the creditors. And then vocabulary, an exempt asset is an asset that a creditor can't touch. Charging order is when you own a part ownership in a company or an LLC or a partnership, and the creditor can't reach into it. I'll talk about that in a little while. And then a fraudulent transfer. Under our fraudulent transfer law, which goes back to the 1500s and the rule of Elizabeth in Old England, if a creditor is imminent and you are insolvent and you transfer assets into an exempt category. For example, let's say I have a bank account and I get in a bad car accident. I'm at fault. So I go and I take that bank account and I put it into an annuity contract. Well, if within 4 years the creditor gets a judgment against me and can prove that the transfer caused me to be insolvent, or that I mentally intended to avoid the creditor, then this can be set aside. So, the first lesson from that is it was not raining when Noah built the ark. So you want to get this done sooner rather than later. But the second lesson is, let's say I did this fraudulent transfer. Now understand, that's not fraud. Fraud is illegal and you're not supposed to do it. You're not supposed to mislead somebody. You're not supposed to lie to somebody for financial gain. But I haven't lied to anyone in my example. I just moved my bank account into an annuity contract. So the remedy here for the creditor is to set it aside. And maybe they could get attorney's fees. So many times in my career, clients have come to me and said, I've been referred by somebody. I heard, they saw your seminar in Miami for the Florida bar. I've got a problem. I've got a jury trial in 3 weeks, and I've got a CD in my name, and my brother-in-law is a lawyer, and he told me not to move it back 3 years ago when I got sued. So what do I do now? And sometimes the answer is go ahead and move it, because all they can do is take it back. But you really have to think through these things. Number one, get it done in advance. Big mistake not to. Number two, if you didn't get it done in advance, let's take a look at the situation and do the best thing we can. Okay, tenancy by the entireties on page 22. Rodney Dangerfield, my wife and I were happy for 20 years, and then we met. Well, you've got 6 unities you must satisfy in order to qualify property as tenants by the entireties. And fortunately, one of those unities is not getting along with your spouse. You just have to stay married with your spouse. But you have to have all these unities achieved. For example, you have to take title to the asset at the same time. I couldn't take a stock certificate in my name and then just write my wife's name on it later, or take an individual bank account and add her to the account.